Knowledge, and we appreciate all of you coming out to join us today. We're going to do about an hour on patent reform, and one of the reasons that we wanted to do this was because of the state of play right now with patent reform in the Congress. I hope folks know that the Innovation Act has moved its way out of the Judiciary Committee, and it's not the only bill. There are other bills that deal with patents, and so what we were hoping to do is that now that we're at a stage where the Judiciary Committee is no longer working on the bill, and now it's coming in front of the full Congress, and people are learning more about it, we wanted to give a quick overview on patent reform, why it's needed, and why it's important to a number of the stakeholders that we have represented here today, folks who represent probably the little guy that you don't always get to hear from in your offices. So please come in and feel free to grab a seat and grab some one-pagers. You can come right to the table. But I think our panelists, we have 4 folks here that I'm going to introduce, are not only show the breadth of the expertise out there on patents and why patent reform is needed, but really represent the little guys, small businesses, consumers, minority communities, and if you don't always get to hear from these folks, we wanted to give you an opportunity to hear from them today, or at least learn about the organizations and continue to hear from them as the debate moves forward. I'm going to moderate and give them a chance to talk, but we'll also open it up to questions about halfway through, hopefully. So feel free to think about what you want to ask, and we'll do some Q&A at the end. To introduce our panel, I'll introduce them in the order that they're going to talk to start out. First, from Public Knowledge, my organization is Charles Dewan. Charles is our director for our patent reform project at Public Knowledge. After him, from R Street, we have Nathan. It's Leamer, right? Okay, Nathan Leamer, and Nathan's with R Street. He's a policy analyst and the outreach manager over at their think tank. We also have, to my immediate right, we have Alan Gutierrez, who represents the Latino Coalition and has been an organization that has been strong advocating for reform. And then also across from me, we have Chris Armstrong. Chris is a representative. He's a director of partnerships and government affairs at the Small Business Majority. So that's our panel of experts. And since we're touting this as both a primer as well as a chance to dive into some of the details where you guys are interested in really diving into details, we're going to start with Charles. And we're hoping that Charles could give kind of an overview of patents. He's a former patent litigator and can talk about why reform is important and what the patent system is like right now. So, Charles, take it away.
Sure. Thanks, Chris. And yeah, again, thanks to all of you for coming. This is an issue that's near and dear to my heart because I used to work as a patent attorney, and saw a lot of really great things come out of that job, and saw a lot of things that I thought ought to be changed. And I think that was one of the things that motivated me to come here and try to work to fix the system that I often saw was broken in a lot of places. So I think we wanted to just start off with a general overview in terms of we have all this legislation going around, but the patent system is kind of an obscure system. So what exactly is going on? And the way I like to think about it is we have a patent system. It's provided for in the Constitution. The Constitution says in the Progress Clause that Congress has the power to give out patents to promote the progress of science and useful arts. And to me, what that means is that whenever we talk about the patent system, you always have to talk about 2 sides of the coin. On the one hand, we need patents in order to make sure that inventors have the motivation to invent. As Abraham Lincoln said, it's the fuel to the fire of genius. The fact that somebody's able to get a patent allows them, gives them the freedom and the encouragement to want to spend some time inventing things. But on the other hand, we also need to make sure that those rights are appropriately cabined for a number of reasons. First of all, if you want to go off and invent something, you have to rely on the inventions of other people. Everybody stands on the shoulders of giants. Everybody works off the inventions of others. And to the extent that the patent system is preventing people from, just using, for example, like basic tools of scientific discovery, that can actually get in the way of innovation rather than promoting it like the patent system is supposed to. And similarly, just as consumers every day, we're using all sorts of inventions, many of which are patented. And to the extent that the patent system is overreaching and actually preventing consumers from doing things that they legitimately ought to be able to do, or allowing patent owners to assert rights that are far broader than they were supposed to receive, that's a big problem for society overall. The purpose of patents is to make sure that we, the people, ultimately get the benefit of these inventions. And to the extent that the patent system doesn't achieve that aim, that means that there's something that needs to be fixed. So generally, the process in terms of how somebody gets a patent is, they go to the patent office. The patent office does a review, determines whether or not this invention is new, it's not obvious, make sure that it meets certain subject matter criteria, and then the patent is just released out into the world. And at that point, the patent can be bought and sold. It can end up in the hands of anybody, and when that patent goes into court against a small business or against an individual startup, it can be a very, very powerful tool when used in litigation. There's some statistics that litigation can cost $5 million or up for a small business. And to the extent that that's being used to assert legitimate rights, that makes sense. But a lot of times, what we're seeing, and there are plenty of examples of this, people will take a patent and say, this means a lot more than this covers a lot more than it originally was intended to cover. For example, we've got MPA Shea who's going around saying we have these patents that cover anybody who uses a scanner, right? I'm pretty sure that a lot of you have used a scanner at some point in your life, and I think you would find it a little surprising if you had to pay $1,000 to this guy for using a scanner. And it's these sorts of problematic assertions of patents that the bills we're talking about today are intended to address. It's the idea that somebody can own a patent and sue somebody over it and demand money for it, based on the fact that it's so expensive to fight back, rather than the fact that they've actually invented something and they should be deserving of compensation. Those are the sorts of problems that we're going to be looking at in the House and the Senate bills, and generally when it comes to patent reform, as we're talking about it right now. And so, I think we'll get into some of the details of exactly what they're looking to do to fix these sorts of problems, to prevent people from taking advantage of the costs, rather than asserting them for legitimate rights. But generally, that's the kind of motivation that we're looking at.
We're fortunate that this effort for reform that's been going on for years now has really been a bipartisan effort. And I know Nathan wanted to address some of the academic and ideological underpinnings of reform, so why don't you go ahead?
Sure, yeah. So R Street, we're a free market-based think tank in DC, and we come from what we call a conservatarian perspective, which is conservative and libertarian, leading principles looking for real policy solutions. And I think this whole conversation about the proper patent policy is really in line with that concept of looking at the conservative constitutional underpinnings of this whole discussion. And I think you can't go any further than looking at the Constitution, which I'm going to read, which Charles already said, but I'm going to say it again. Article 1, Section 8 of the Constitution, to promote the progress of sciences and the useful arts by securing for limited times for authors and inventors the exclusive right to their respective writings and discoveries. This is a really fascinating thing in the Constitution because it's actually giving Congress the right to do something for a particular purpose, and that is for the progress of the arts and the sciences. Many of these same founding fathers worked to pass the Patent Act of 1790, which was the first patent statute passed by the federal government. The law was concise, defining the subject matter of U.S. patent as any useful art, manufacture, engine, machine, or device, or any improvements thereon, not before known or used. It granted the applicant the sole and exclusive right and liberty of making and constructing, using, and vending to others to be used. The duration of each patent, it's funny because it's not much different than our own era now. The duration of each patent was assigned to the Patent Board at the time, which is the precursor to the USPTO. It could be any length as long as it did not exceed 14 years. It's actually not that different than what we have now, or what we'd like to have now. I'll let you know this. The Patent Board members started out, the first ones were Thomas Jefferson and Henry Knox. Thomas Jefferson, the great inventor, also wrote the Declaration of Independence, and Henry Knox, who not only saved Boston in 1776, but also was a great book seller in Boston. So these are two individuals that have very much understand copyrights and patents. The principle and practice of patent law has not really changed too much in 225 years of the concept. In many ways, the format facing Robert Fulton or Thomas Edison are similar to what we have today. Innovators go creating ideas and bringing their inventions to market. Unfortunately, over the past decade or so, we've seen this flourishment of predatory patent trolls, you may call them. And it's the concept where you're distorting the law as written and distorting the system to stifle innovation and at the same time keep new things from coming to market and basically corral the market for yourself. What's amazing about this is that the authors of the Constitution, James Madison specifically, explicitly wrote the fear of this happening, saying we should guard with strictness against abuse of our patent system. So James Madison, the author of the Constitution, is calling on later Congresses and later people to constantly come to grips with the question of whether we have a balanced patent system. Building off that, Adam Smith, the great free market economist, also described patents as necessary evils to be handed out sparingly, because it's a form of a monopoly, a limited monopoly. We should be very careful about limited monopolies, and we've always had that in this country. One of the concerns that I keep on hearing in this debate is that this is undermining the patent system, or that any efforts to have this discussion is trying to begin some anarcho-capitalist world without any intellectual property. And I tell you, no one in this discussion, in this room, or in the people at Congress who are pushing for this conversation are looking to do that. What they're trying to do is having a conversation that fulfills the constitutional mandate for the progress of science and art. I'm going to give you two quotes here to kind of end with this opening conversation. And they're from two, I think, really well-known free market libertarian-leaning economists. Frederick A. Hayek, you may have heard of him, explained in his Individual and Economic Order, the problem of the prevention of monopoly and the preservation of competition is raised much more acutely in certain other fields to which the concept of property has been extended only in recent times. I am thinking here specifically of patents, copyright, tech, trade, trademarks, and the like. It seems to me, beyond a doubt, that in these fields, a slavish application of the concept of property, as it has been developed of material things, has done a great deal to foster the growth of monopolies, and that here drastic reforms may be required if competition is made to work. Milton Friedman echoed the same comments in saying that clearly patents and copyrights are necessary. And let me get here this great quote because I love this. At the same time, there are costs involved. For one thing, there are many inventions that are not patentable. The inventor of the supermarket, for example, conferred great benefits on his fellow man for which he could not charge them. And as a guy who loves going to the grocery store and getting good craft beer, I'm thankful there are no patents on supermarkets. But insofar as the same kind of ability is required for the one kind of invention as for the other, the existence of patents tend to divert activity of patentable inventions. He also goes on to explain one thing is that trivial patents, or patents that would be of dubious legality if contested in court, are often used as a device for maintaining private collusive agreements that would otherwise be more difficult or impossible to maintain. As we have a dynamic economy with new software and new iPhones and new laptop ideas and things that we're having innovations at a huge, major rate on different platforms and whatnot. We should be looking back at the Founding Fathers and the original authors of this Constitution and these free market economists I quote, who conservatives love to quote, to look for a patent policy that makes sense of the balance. Not trying to throw out the baby with the bathwater, but finding a way that balances the approach for protecting the rights of individuals who have created these patents to bring to market, but at the same time for the progress of the science and the arts. I'll say one other thing. The best example of this in recent pop culture has been the TV show on HBO Silicon Valley. And I guarantee you all should go watch it, because the story of the second season is entirely about a couple of startup entrepreneurs being taken advantage of by a system that has taken this balance off kilter. And while this is a heady issue that constituents don't think to talk about, I think shows like Silicon Valley have done a great way of describing this in a way that we can understand as policymakers and as thinkers.
Great, thanks, Ed. We're going to go to Alan and Chris now, because I want them to talk about some of the concerns that they're hearing about why reform is needed from their organization's perspectives. And so why don't we start with Alan, and feel free to tell folks about your organization.
Sure. And thank you very much, everyone, for being here. And certainly, for us, we've been very strong advocate as it relates to patent reform, even as last year as well. And we now we're looking at hopefully getting across the finish line. But the Latino Coalition, we're a nationwide nonprofit. We actually just celebrated our 20th anniversary last week, 2 weeks ago here in Washington, D.C. And our main focus is small business, creating resources and advocacy for small business, higher education for Latinos, affordable health care for self-employed and small businesses, and the coalition growth. We're one of the largest Hispanic business groups already, and we're on the move to continue to grow. We have over 70 organizations across the country and 1.1 million business owners in our database that we reach, which right now, we have, according to the census, there's 3 million Hispanic business owners. So there's 1/3 that we work with closely across the country. One of the things that we say in regards to this is that this is not just a big corporation issue. This affects everyone, and it affects small business. From the corporation that's being affected to them passing the cost on to the consumer, as well as small business who it affects their bottom line and trying to keep the doors open and keep moving forward. So for us, we see that small businesses, they wear a lot of hats. The owners wear a lot of hats. From accounting to marketing to social media, and you name it. And last thing that they need is receiving a demand letter and a patent troll. And unfortunately, some of these what's occurring is that they're going off and paying it because they don't have the time and effort to be able to fight these particular frivolous lawsuits. And for us, we see that as damaging for many reasons. It takes away from their time to focus on their business. It takes away from their opportunity to expand. It might affect their workforce. So those are the things that we see in a sense. That the Innovation Act that we was out of the committee, there's a lot of areas that we are in favor of, obviously, as a group, in terms of looking at demand letters, that more truthful information to come out, protect the innocent customer, stop the discovery abuse, and the fee shifting as well, in terms of it. That there's the fees can be awarded to the party that wins. Those are some of the areas that we see that are favorable to small business, that will help them as well. From that perspective, that's why we've been very strong on this issue and within the coalition to really get the messaging out. But again, at the bottom line is that it's not a corporation. It's everyone that's getting affected here, and we thank you for your time for being here to learn more about why we're supporting this.
Chris.
Yeah. My name's Chris. I'm Armstrong. I work with an organization called Small Business Majority, and we represent small employers 100 and below. And so we approach this issue sort of in two different routes. One from the sort of entrepreneur and innovator perspective. We represent most all entrepreneurs, because all it takes is for you to file an LLC and to call yourself an entrepreneur. All it takes is file a little bit of paperwork. I think that's a practice many of us in this town are very familiar with, especially if you might be leaving the Hill. So from the entrepreneur's perspective, this is an issue because as you want to build a business, you're very often, as my colleague said, you're standing on the shoulders of giants. You're standing on innovations that have come before you, and you're using to build your own business. But the aspect you don't think about is sort of the small employer Main Street business perspective. And from what we've seen, we've done polling on this issue that I'll talk about in a second. But what we see is small employers without knowledge walking into a situation where they're using, in the most extreme examples, using Wi-Fi that is the target of a lawsuit that then means that they have to pay out as part of that lawsuit, and they didn't even know. And this is like the last thing. These are like business owners who, just to survive the holiday season, are putting up like a $4,000 refrigerator on their personal credit card because it's the most available line of credit that they have to get through like a holiday season. Are then being told that they have to pay $2,000 because they're using Wi-Fi for their cafe. Like this, and those are some of the most extreme examples. And if you're looking for, and I know when I talk to the Hill, we're looking for political reasons to do something. There couldn't be more support for an issue like this. In our polling, that's 47% Republican. If you look line item, every provision of the Innovation Act, there is not less than 60% support from small business owners. Like 77% of small business owners believe that there should be action taken so that there is not frivolous litigation that will adversely affect them in their business. If that's not at the just to act on something, then I don't know what it is. So from our perspective, and please feel free to take our one pager, and if you are interested in some of our expanded polling, which is a larger report, I'm happy to give folks the link. We see that business owners overwhelmingly support this, and small employers want to see action on this. So,
Great. Before we get to more of a dialogue and questions, and I know folks come at this from different levels of experience or different levels of knowledge, so we do have some handouts here, including the polling that Chris was talking about from his organization. R Street gave us some basic glossary. I don't know if you got the glossary, but you should check it out. What we're going to do next is I'm going to ask Charles and Nathan, if you want to weigh in as well, to kind of run through some of the key provisions or key issues in reform that we're looking at in the Innovation Act, and why they're important. These are some of the key aspects of reform that I think all of us will be looking to see are maintained in the bill, or that we might have concerns about, depending on which topic. It might be something we're for, or something we have concerns about. But I think everyone should know that there are two bills. There's the Senate bill, the Patents Act, and there's the Innovation Act in the House. And from what we hear, the Innovation Act is going to be moving to the floor, hopefully in the month of July. So there are no bad questions, but as we go through some of these aspects of the bill, think about if there are things you need clarification on or defined. And I know our group will be happy to go through it, or to talk about some of the stories behind why they're important. So, with that, Charles, you want to go through some of the high level
Yeah,
ones?
definitely. And yeah, I mean, this is a nice, cozy setting. So if any of you have questions, feel free to jump in. So I think I wanted to start off with something that Alan said, that this is not about big businesses, it's about small businesses. And we had a lot of comments from both Chris and Alan about how small business can really be affected by this. And it reminds me that there's a great study. It was published in the Stanford Tech Law Review, I think last year, by Professor Colleen Chen, who she interviewed a lot of small startups and small companies, and asked them, have you ever received a demand from a patent assertion entity, she called them, and what did it do to you? She found a good number of them had. I think there was a follow-up study that Robin Feldman did that found that right after they get that first round of funding, the thing that lets you move forward, that's when you start getting all the lawsuits, right? That's when you start getting all the demand letters. And she asked them, so once you got that demand letter, what'd you do? And she got a range of responses. People said that they cut out products that they were working on. They stopped development of new things that new R&D that they were doing. They had to turn down employees they were planning on hiring or fire employees because they couldn't pay them. Some of them had to change business lines. They went into other business lines. Some of them just completely went out of business. She also asked venture capital investors, what did you do when you found out that? What would you do if you found out that one of your companies might be under attack from a patent troll? And they said, yeah, that would be a very important factor. 75% of them, I think, said that they were much less likely to invest in a small business if they saw that sort of threat on them. So I mean, these are real problems. I mean, besides just the particular stories we have, we have some good data that says that this is a big problem. And big companies they can deal with this sort of thing, right? They've got big armies of lawyers. They've got they got lots of they have lots of resources. But I used to work at a tech startup out in Silicon Valley. We had maybe 4 people. The amount that they were paying me per month would have been more, or would have been less than most of the demands that I've seen so far. So that's kind of the scale that we're talking about. This can have a really big impact on those businesses. And so the first of the reform efforts I want to talk about really gets the heart of that. That deals with the abusive demand letters. We get these. So what happens is that patent owner owns a patent, sends out letters. Frequently a lot of these letters, or maybe hundreds of these, to small businesses. There's one who just kind of went through a business directory and just picked out names out of a phone book and sent letters to everybody in the phone book. These letters, you know, say I've got a patent. If you pay me this amount of money, I will go away. And otherwise, Otherwise, I'm planning on suing you in a week. They frequently give very little information. They frequently don't tell you why they think you infringe. Often because they didn't even investigate whether you infringe. They just want the phone book. They, you know, frequently will use threatening language that is misleading or even deceptive. There are examples of some entities who have sent out letters asserting invalidated patents that have been invalidated in court. They were still sending out letters saying, you know, you infringe our patent. So, you know, there are a lot of these bad practices, and dealing with those sorts of, you know, bad practices at the very beginning against the smallest companies, you know, I think is a pretty obvious reform. And that's what we're talking about when it comes to dealing with abusive demand letters. So, you know, I'll let anybody else in the panel jump in. Get particular comments on that.
I was actually going to add one, since he mentioned startups, one of my buddies, good friends from college, he was that guy who had a picture of Bill Gates on his wall, that he met Bill Gates, and he was so proud of it in college. He was that guy. Whenever he graduated from college, he moved out to the West Coast and worked for a large tech industry company, and told me recently that he was actually paid rewards to come up with like ridiculous patents, like software patents, like things like connecting your email to how it connects to a listserv type things, like basically coding, essentially just changing code and calling that a patent, and he would get rewards from his company to do this. He didn't realize the problem with it because he's 23, 24, brilliant as they all get out, until he moved to a startup. And he started realizing what was happening was that he was basically making these broad patents, that they're poor patent quality. That's something that's another issue here. That then patent, PAEs, patent assertion entities, are then sending these frivolous, ridiculous demand letters to his tech startup. And recently we had a chat over beer about it, and he's like, yeah, I really feel bad about my part in that, because what I was doing wasn't a patent to myself. I was doing it for the company I worked for. I was doing it so that I could help a large entity keep out competition. Little did he know that would be himself a few years later. And so I think that's something that I wanted to add to what Charles was mentioning, is that these demand letters are about broad patents specifically. They're things that that really you wouldn't think of as unique, or really wouldn't pass muster according to the original patent board. So that's what I just wanted to add to that.
So Charles, before you move on to the next piece of reform, companies need some way to help enforce their patents, when there's a valid claim. What are we looking for in demand letter reform to make that process better?
Yeah. I mean, that's a great question. I think that a lot of the concern with particularly demand letter provisions, and with a lot of the other things, is making sure that the legitimate cases still get through, right? And so the idea is, when it comes to demand letters, for example, if you are sending out a legitimate and honest and reasonably informative letter, then you are acting reasonably, and there should be nothing wrong with that. What we're going after is abusive letters that contain misleading or deceptive statements, the kind that the FTC would go after in just about any other context. The way that I think about this is, when it comes to demand letter laws, this is just consumer protection applied to a very specific area. It has always been the case that we protect consumers from misleading debt collection practices, right? You are not allowed to call somebody up in the middle of the night and say, I'm going to break your arms if you don't pay up this debt. There's no reason you should be allowed to do the same thing except with a patent in the letter, right? The idea is that we need protections for those sorts of consumers who might be, who might not understand what's going on when they receive one of these letters. They're, who would, read one of these things and think, do I have to pay this immediately? Are they going to sue me tomorrow? I don't know. It's the exact same problem that we've been dealing with in just about every other consumer protection area. We're just applying it to the patent space, and that's exactly what we're looking at. We don't want to prevent legitimate cases. We want to prevent people who are trying to take advantage of the system and take advantages of imbalances in information and expertise. So that I think is how we're trying to address this sort of issue.
What are some of the other consumer-oriented reforms we're looking at in the legislation?
Yeah, I mean, the other one that jumps out to me is the customer suit exception. This is the idea that Chris was talking about this idea that if you use Wi-Fi, right, you infringe a patent. And there is this one guy out there who will go after people who are just using Wi-Fi. Now, I don't know about most of you, but when I use Wi-Fi, I'm just using the router that I purchased from like Amazon, right? I didn't like configure anything or write any code to do anything. I'm just using something that I bought. And if you think about it, the person who made the router, they've got all the expertise, they've got all the knowledge of like how the thing works inside, they've got all the important documents, right? They're the right person to be fighting this case out legitimately. Why would a patent owner want to sue me? Well, the reason is that I'm in a very bad position to defend myself. I'm just like a small guy. I have none of this information. I would have to hire experts to go and discover all of the inner workings of my Wi-Fi router. That's very difficult and very expensive. And so I'm in a very, very bad position to try to defend these sorts of suits. And conversely, if you want to abusively assert a patent, I'm a great target. So the idea is let's do something to try to alleviate that. And the way that they figure out to alleviate that is to say, well, if customers who purchase off-the-shelf products are being sued over patents, if the manufacturer agrees to this is only if the manufacturer agrees to this, the manufacturer can take over the suit. My lawsuit is stayed until that manufacturer suit is resolved. And a lot of those issues can be dealt with in a much fairer and much simpler way. And that way, then, if there's something still left, nobody's stopping the patent owner from still coming after me. But at least we've resolved all of the key issues up front in a reasonable way. So that again is another really important protection principle because of the fact that it makes sure that stuff that you and I just buy off the shelf doesn't result in us standing alone in the patent
fee shifting is another big thing that we're seeing change here.
Definitely.
Attorney fees can be awarded to the party that wins the patent infringement case if the loser pays, and so that's a change too. Because if you're a small business or a small entity, you're getting caught up in a fight that you can't win otherwise, or if you do win, you're still going to have to pay out hundreds of thousands of dollars to say that you defend it. So the question is, what's the opportunity cost of winning versus losing? Do you settle and move on and try to start a new business, or do you fight the case and hope that for example, one of the cases that we were reading about, where story I was reading about earlier was where a guy who started a tech startup was sued for infringement, and he fought that back after a few years. And then the same PAE came back with 2 or 3 other lawsuits and saying you're infringing on this and this and this. And so it's like the war that never ends for these startups. And I'm sure you have stories where that's a major issue.
Yeah, no, absolutely. And I think that is absolutely true. But I also want to sort of reaffirm, we love talking about the tech startup and entrepreneur realm, but I also always want to sort of reaffirm the sort of Main Street business implications of some of those issues. And I think that a lot of there's as folks have said, like there's so often businesses that are so not in the realm of even trying to innovate. They're just a deli on the corner who might have fallen into some of these issues or gotten a demand letter by no understanding of their own. And so I think it's important to also reaffirm that this is a consumer issue. All of these small business owners that we're talking about, we talk about business, and I think sometimes we think, small business, they have, a certain line of credit, they're probably worth like $500,000. They can probably afford a certain amount of legal fees. These are folks who are literally taking on their business's expenses on their personal credit cards, and literally their business's expenses, their business line of credit is their own line of credit. And that brings in other issues of how the Credit Card Act and other things work, so I don't really get into that. But it just to drive home that this is not just a business issue. This very often is a consumer issue, and this is affecting real families and real households, and not just the tech startups and so forth. But I can go into other stories, but I'll yield.
Oh, yeah, good. Yes.
One of the parties that I know that would relate to farmers in particular, how do the proposals that have been put forward relate to biotech, agriculture, and the ability and GMO crops, things like that?
Yeah, we don't necessarily represent a lot of farmers, and we tend not to. But so I will actually defer because I don't necessarily, I can't give you a great answer to that question. But certainly affects, I would say, it affects innovation. It affects small farmers who are trying to start and build their business. I don't know if other folks have.
So I'll tell you a sort of like legal history story. This is I want to say this is like the 1870s. There's a paper by Colin Chan who cites a paper from I think the 1940s by a guy named Earl Hader, who wrote the story about a number of incidents in which there were some patents on things like barbed wire and swinging gates. And what would happen was, these farmers they would just use these sorts of things. People use barbed wire. They make barbed wire a lot of times. And someone would just come along, up to their farm and say, "Hey, I've got a patent on that door that you've got there, and you've got to pay me some money, or I've got a patent on that scythe that you're using to chop down your weeds. You have to pay me some money." And this became quite a big deal, to the point that the farmers actually went to Congress and asked for a number of reforms to the patent system to make it harder to get these sort of patents on like ordinary farm tools. So yes, I think that a lot of the patents we're seeing right now are software patents, and that's because a lot of the businesses we have right now are software businesses, right? But there's no reason that these sorts of issues couldn't come up with in any sort of technical area. One of the areas that we look at a lot is 3D printing. 3D printing is a really cool area. Really up and coming technologies. We run a 3D printing event every year where you can see some like the new stuff that people are building. But you can totally imagine what's going to happen, right? Once this becomes a big consumer technology, once everybody's got a 3D printer in their home, now are we going to start having patents on printing out bowls with a 3D printer, right? Now every time someone makes a bowl, right, you have to pay somebody a patent license, or you might be liable for like a patent demand letter. Who knows? And that's where I think like those sorts of concerns really have to come in, right? It's and even like with the farmers, the tractors that they use, right, are car devices that contain computers in them that run all sorts of software, right? That software has gotten them in unexpected trouble in a whole lot of ways. We're talking about like copyright stuff. There'll definitely be like patent stuff coming down the road. These sorts of issues really affect everybody because of the fact that everybody just has to use technology somewhere, right?
Those are all valid points, but
Yeah.
the reason I asked the question, my real concern, in particular with genetic modification and the introduction of genetically modified crops, when companies can come out and patent genes in particular, genes that can spread via pollination across plants, and farmers have you can't block pollination.
Yeah,
And
that's
when a company comes in and sends you a letter of demand saying, my genes are appearing in your crops, and I have a patent on those genes. If you're able to patent genes, there's no ability to control it, right?
Yeah, that's the Monsanto Bowman issue, right?
Right.
Where they said that like if you grow the crops using genetically modified seeds, then you have infringed the patent by virtue of just growing something. Which it was a strange decision, but I mean it's a decision that's out there. But yeah, I mean the Supreme Court has been spending a good deal of time trying to work out the details of what sorts of genes can be patented like natural organisms. And one of the things that's really important for those sorts of cases is, regardless of how the law works out, people need to be able to get in the door and fight the cases, right? Dan Ravisher, he's a big guy in this area, and he'll take a lot of these cases pro bono. I mean, like he can only do so many of them. He's like one of the few guys who does this. And what it means is, particularly for these sorts of cases that deal with like the patent subject matter issue, whether or not you're allowed to patent these sorts of categories of things, being able to deal with that sort of issue at the very, very beginning of the case, what's called the motion to dismiss stage, is pretty important. And so the courts are working on this issue. The courts are trying to figure out how do we structure things so that people can actually bring those sorts of cases, bring those sorts of issues up at the very front of the case. But that's actually also in the legislation. Some of the stuff that talks about discovery reforms, which is about pushing the really expensive parts of discovery off until, among other things, the motions to dismiss have been resolved. Right? That's in the bill. And if those sorts of things are available, then farmers who want to contest these sorts of patents will be able to do so without having to start going through document exchanges and depositions and all of these fairly expensive things. That's actually a fairly important. That procedural point is actually pretty important to making sure that people are able to get the substantive law rights. Yeah, we're going to push it.
My name's Scott. I'm with Rep. Huffman's office, who co-sponsored the Innovation Act last Congress and again this Congress. A lot of folks are coming to us saying we just did a lot of patent work in 2011. Why are we doing this again? The reforms aren't even in place. The Supreme Court's been taking up cases that have to do with fee shifting and other sorts of things. Why doesn't Congress just take a back seat now, let PTO and other folks try to just sort everything out from 2011 and a number of these hot issues and see kind of where that is and then start the conversation from there?
It's a great point.
Curious your thoughts
Folks
on
feel that a lot,
that.
that we're moving too fast. Why do we need to
Yeah.
do this right now? And I'm sure all of you can talk about why this is important and what happens
Yeah,
if
is
we
anyone
don't get reform now.
Would you want to go first?
Or,
Okay. One of the things I would add, one of the things I've been, especially with the constitutional argument in the background, Congress calls us to deal with taxes, and we constantly bicker about taxes in this country, whether they should go up or down. And if there was a tax increase yesterday, I'm assuming today there would be efforts to make a tax decrease the next day. I guess my point is that things that are enumerated in the Constitution are things that I think Congress, especially with their powers, are supposed to be constantly having this discussion on. And I think Charles would probably elaborate on the differences with the AIA, the American Invents Act, versus what the Innovation Act and the Patent Act and the Senate are trying to address. And I'll let him kind of go into detail there. But I would say, just because something has been passed, especially in an era where, for example, Microsoft Windows 95, the patent finally ran out on that. I don't know of any software techies who are excited about the fact that they now have that in the public domain, because we have a world where technologies are changing at a radical rate. Look at your iPhone. For goodness sake, the apps on your phone from a couple of years ago, I don't use them at all. There's been so many iterations and whatnot. I think we have a situation where we are on the cusp of a real, we're in the middle of a revolution in terms of technology, and I think that some of the issues that AIA addresses some of the issues that were dealt with in other aspects of industry, which opens the door for the Innovation
But
Act.
couldn't Big Pharma come back to you and just say that we invested 10 years of work and billions of dollars in a single patent or two, and that kind of technological argument doesn't really bear in all sectors of the economy?
Yeah, no, I
Curious.
think that different areas have different ways of innovating, and that's fine. And I think that when it comes specifically to that, if you look at the patent laws, there are a whole lot of accommodations to deal with that specific problem. There's patent term extension, there's the additional FDA exclusivity period. There's all sorts of things that specifically accommodate the fact that drug discovery takes a long time, and that we have to deal with that sort of problem. So I think that the particular issues that pharmaceutical seed are actually dealt with in a lot of different places. Just one quick note, I'll get to.
I also want to give these guys a chance.
Yeah, I just want to very quickly address the AIA point. AIA was passed just recently. AIA dealt with substance of patents. It dealt with ways in which the patent office can improve the quality of patents by reconsidering them, making procedures that make it easier to consider them. That's the side of what sort of patents should exist out there. There's another side of what do we do with patents once they're issued, right? The question of the substance of patents versus how are patents used. The bills we're talking about now deal more with that side of things. That side of things wasn't really touched by AIA. AIA has one very small provision that really hasn't worked very well. I don't see anything unright about taking a look at it at this point.
Chris, Alan, before we go to another question, what happens to your constituents if we don't see this reform move forward?
Yeah, and I think that, from the standpoint, you mentioned, some was done in 2011, but if we have an opportunity right now to tackle some of these issues that are facing small businesses, this is not only the only thing that small businesses are facing, in terms of challenges. There's more regulation that's coming down the pipeline. There's obviously what we're looking at Supreme Court in terms of ACA. So there's other areas that are, building one after the other of challenges for small business. If we can unifiedly pass this, this one less hurdle and one less challenge that small businesses need to worry about. And that's from our perspective, from that why we're so a strong advocate and publicly and on the coalition as well from that standpoint. So those are some of the talking points that we've been when we're interviewed and why we're so strong on it from that perspective.
Yeah, just to echo that, I think, and I don't want to be a dead horse, but I think it's hard to look at some small business owner in the face who's just been hit with a huge lawsuit to say like, hey, the courts are going to figure this out. But it's like, I think there are actions that can be taken right now to help business owners who are facing these demand letters, these issues right now, that can be quick solutions to help prevent any business owners that are going to potentially take on more debt, like hurt their business in any way. And I think those are the opportunities I think that we should be taking, and those are not necessarily the opportunities that we know for sure that the courts will tackle, or even necessarily tackle in the way that should be tackled in a smart policy way. So I think it's important for us to be proactive about this and approach in a way that, knowing that there are consumers and there are people that are being affected by this, and our constituents being affected by this, and approach it with a proactive stance.
Good question here.
Thanks for holding the forum very much. Two related questions. One is,
Oh,
I'm sorry, Bill Richmond. I represent Qualcomm, which is on the other side of this. They haven't been a patent plaintiff for 6 years and are patent defendant. Sued by trolls constantly. They're still opposing it, and that's kind of my question. Why does the panel think that there's so much opposition from non-troll patent innovators like bio and pharma, university, medical device manufacturers, venture capitalists who invest in it? I say universities, where if the committee would say because they're all misreading the bill, the patent councils are all wrong, the committee councils are right, won't hurt them. Love to hear your thoughts on that. And a related question is the way it's advertised, for instance, on the question of customer stay, protecting mom and pop, buy Wi-Fi from Best Buy. Everybody agrees with that. The way it's written is the Wi-Fi manufacturer is also stayed in the litigation. And there was even an amendment voted down opposed by that, which would have said allowed them to be sued. How do you explain that variance between the narrative and the way it's written?
Well, okay, so I guess to start off with the larger question, I think in terms of the people that we're hearing from who are saying that this is an attack on patent rights and that these are important property values. I think Nathan talked a little bit about that. I also think it's actually a smaller majority than it's a smaller minority than it sounds like. We did some research in a brief that we filed just on Friday, actually, in which a number of companies said that patents are incredibly important for investment in the software industry, and the software industry would fall apart if we didn't have strong patent rights. And it turns out that if you actually look at the research on this sort of subject, most venture capitalists, most startups, most small businesses, most people in the software industry disagree. They say that things like first mover advantage, being out there with your product first, just having a good product out there, those are the sorts of competitive advantages that really drive a business. And patents can actually get in the way of that. It's a little surprising, at least to me, coming from a startup perspective, that people seem to be saying that these things are so essential. Whereas I think ultimately what we're seeing is that the small businesses who are concerned about this sort of issue are concerned on the other side. They're not concerned with being able to sue everybody over their invention. They're concerned with the possibility that they will be sued by somebody who has one of these patents that covers all sorts of things that nobody was really expecting. The favorite case I have is this guy who got a patent on like a method of filing documents that were sent in by fax. And through various actions at the patent office, twisted this patent into something that supposedly covered sending emails, and then went off and basically sued everybody who was sending emails. This was just such a ridiculous argument that even the courts couldn't buy this sort of thing. But they made a lot of money by just trying to license their patent off to people who weren't able to fight them off, and the court recognized this in awarding fairly substantial sanctions against them. So this is the sort of problem that I think the innovative community is really facing. Now, in terms of the the customer say language and some of the other language, I don't really see that issue. The language seems fairly clear that number one, it uses the word manufacturer in it. So it's a little hard for me to believe that it somehow is like not about manufacturers. And second of all, it's voluntary, right? If the manufacturer wants to push off the suit to somebody further up the chain, the other person up the chain has to agree to allowing the manufacturer to do that. So it seems a little odd to say that somehow manufacturers get out of suits because if the manufacturer is getting out of the suit, somebody else has agreed to take it on. And I think that that's the case with a lot of these provisions. That the way that they work does work out. Now I recognize that there are certainly a lot of criticism of these. There has also been a whole lot of work in revising them to accommodate these sorts of concerns. The customer say provision, for example, has been changed numerous times from what I've seen originally to much more closely target the particular sorts of aspects that are concerning. And I think that that's been the case with a lot of the other aspects of the bill. So I think that those comments have had their place. And furthermore, all of a sudden, out of the blue, we have this discussion about inter-parties review.
What is that?
And so, yeah, so
Well, if you read the R Street glossary, go ahead.
Well, actually, do you want to?
No, well, you do that.
Well, okay, so we just had this question about, what did the AIA do? And what the AIA did was it implemented a number of procedures by which one could go to the patent office and say, hey, this patent is actually really problematic. I think that it's invalid because of, this and this prior art. People were doing this years before the patent showed up. So patent office, I think you need to take this back. I think you made a mistake. As you can imagine, this is a pretty important thing for the public interest, right? The example that I like to use is the work that EFF has done on this podcasting patent. So there's a guy who has a patent. He says it covers all podcasting, right? So any of you who has recorded sound and put it online, that is basically the process of podcasting. This guy says that he owns a patent, or he has a patent on the process of putting up an indexed file of a number of audio recordings.
Didn't he invent it in the 90s with tapes or something?
Yeah, it involved cassette tapes. So there's an issue right there. But basically, when this guy went around and told a whole bunch of medium to large podcasters on the internet, hey, pay me a certain amount of money or else I'm gonna sue you for patent infringement. And the problem is, if you're one of these podcasters, right? You're not making a whole lot of money. You're not making the millions of dollars that you need to go off and fight a patent litigation. You're not even making the $500,000 you need in order to put up a challenge at the patent office through the inter-parties review processes, because they're fairly expensive processes in their own right. No individual is going to have the resources to deal with this. But if you have a public interest group like the Electronic Frontier Foundation, or you have some sort of collective organization, there's one called Unified Patents who does the sort of thing of aggregating the number of groups to deal with these sorts of patents. Those sorts of groups can actually deal with this, and EFF filed a challenge through the IPR proceeding, and won. They were able to show that the patent was invalid. So this is, and EFF, of course, right? They I don't even think they have a podcast. So, they don't directly benefit from this, but everybody else does, right? When an invalid patent is invalidated, everybody else gets to use it. Nobody else can be threatened by it, and that's actually a really important thing. So, it's important that we protect these sort of procedures, and what's concerning is that a number of companies have managed to basically get language into the bills that say we're going to cut these procedures down, and we're going to make it hard to use, and hard to push through, and that I think really cuts against kind of the public interest principles that we're trying to go after.
So that would be a provision you think we would keep an eye out for.
Yeah.
That would be good.
If it was added on the floor, there would be a concern.
Yeah, and so this is a good point at which we can talk about kind of the differences between the House and the Senate bills. The House is
timekeeper, we have about 5 minutes. So if folks have questions, please. Why don't we get to his question and then we can come back to it.
Yeah.
Sure. Addressing the IPR reviews, you mentioned you sort of tied into EFF does not have a direct interest in that, but they're still able to participate because you don't need to have direct interest. which several people who live on Wall Street have taken advantage of, and are doing serious harm to biopharma companies and making themselves buttloads of money, and they're not saving anyone's podcasts.
Yeah.
Are you guys
this
open
Kyle
to
Bass business, right?
narrow reform on that issue?
The first question is, I haven't looked at patents. I haven't seen anybody who's looked at patents. I don't actually know if these patents are any good, right? And I'm not sure anybody actually does.
I mean, they're pretty upfront.
The patent
that
office
they
hasn't.
don't care.
Well, they're being pretty upfront that they are selling short the stock, right? They say that the patents are invalid. Like, they've been actually pretty clear about that. I don't know if they're being legitimate about that, right? The patent office hasn't ruled on them yet. And, when the patent office rules, we'll have a better sense of, whether or not these guys have legitimate claims or they're just being bogus, right? But, even if we assume that these guys are just making bogus claims, right? The problem is the fact that they're trying to make money off of it, right? And I think that the provision that the Innovation Act has that deals with this sort of thing by saying you're not allowed to sell short these sorts of things, and that you're required to disclose this sort of information, I think that's the way to deal with it, right? This is somewhat best disinfected, right? If we and the patent office and the patent judges know that this is why this guy is filing it, I think that puts everybody in a better position to understand what's going on. Again, if the guy is actually putting in the work of finding really bad patents and finding the prior art to invalidate them, he is doing a public service. If he's not, then he should be called out for it, right? And the right people to call him out for that are the patent office who will tell him no, your claim is bad, go away. And at the point that they rule on the petition, which should be within I think a month or two, we will have the answer to that. But yeah, no, I completely agree that there are some abusive practices. They should be dealt with in targeted ways. They shouldn't be dealt with in ways that would wipe both EFF and these guys off the ability to do that.
Question back there.
Joe Russo with the House Judiciary Committee. Just to harp on that point again, we addressed that Kyle Bass issue at markup. So it was newly included within the last couple of weeks, where someone would have to sign a sworn statement saying that they weren't shorting stock or manipulating the stock market.
Yeah, that was the point that I was referring to.
I would also add to that point, what I found is maybe at times frustrating on this legislation, because whenever you have to read more documents, it can be frustrating. But the good point that Judiciary has done, and I hope that the people involved in the bill and on the Senate side as well have done, is they've constantly had this conversation. They're opening the dialogue for many people to actually open the change. In Washington, D.C., where you see a lot of times you close the door and you just ship it to the floor, and there it is, and we have to yes or no. I think the ample time that many groups from different sides of this debate, and outside groups like us and others, and members and offices, have had time to constantly go comb over this and to see where the problems are, and the openness that there has been to certain amendments and ongoing conversation, something that is encouraging to me. I think it's frustrating too, because I love it. Sometimes you just want it to be done and just move on, but the open dialogue has been, I think, good on that point to deal with some of these IP review questions and some other issues, which is a testament to, I think, the opportunity we have for reforming the Senate's version as well, which is its own moving along as well.
Right. Both Senate and House Judiciary Committees had extensive markups with multiple amendments, so
Yeah.
There's actually a really great debate to watch. Other questions? There's people sitting behind me. If I'm not okay.
Yeah.
Oh yes. Go ahead.
Yeah, Mario Trujillo with the Hill. If these two bills in the House and Senate do move forward, what's going to be the biggest roadblock in merging the two? What's the provision that's going to be the biggest roadblock?
I don't know if you guys have an opinion on what's the most controversial provision out there right now. I mean, we aren't dictating the process.
Yeah.
There are all
There
outside
is a
groups.
difference in venue.
Yeah,
that would be, I think, one thing.
The two big differences I think are the venue provisions. The venue provision is in the Innovation Act. It's not in the Senate. It's not in the Senate Patent Act. I'm not sure what the thinking is over there about that provision.
And explain what the venue
Yeah.
provision is for laymen.
Yeah, so basically the problem is that right now you can more or less bring your patent suits anywhere you want in the country again, because most companies they operate nationally. So if you sell a product in Texas, then that means that you could be brought into Texas to fight the patent lawsuit. And what this has meant is that certain districts, such as this one particular district in the Eastern District of Texas, have become very, very popular because statistically they have to be more favorable to the side of the patent owners. So patent owners like bring the suits there. The venue provisions would impose stricter requirements saying you have to bring suits in only certain places that are more reasonable. In line with a number of cases from the federal circuits, which have said it was so ridiculous to bring your case in the Eastern District of Texas because there's absolutely no reason to bring it there. None of the evidence is there. None of the people are there. So I think that's going to be one question. Does the Senate want to take up that sort of language? The IPR provisions, they differ fairly substantially. Although my understanding is that both of those provisions are kind of works in progress. So my guess is much like the other provisions with like legislation with the fee shipping and everything, the language will move closer together as these things kind of work their way through the floor or through their respective floors.
I would also add one of the things I've noticed is whenever you have a bill or an issue like this where it's bipartisan, led by bipartisan groups, sometimes the typical right versus left paradigm doesn't really fit, and I think sometimes that can be tricky for House leadership and Senate leadership to address. I mean, that's just a natural situation where when it's not necessarily the majority leader in the House or the Senate pushing it, but actually a coalition of people from the left and the right completely in this conversation, that brings it up. That's not to say that House Senate leadership is opposed to it. It's just a natural fact of the reality that sometimes when you don't have Francis Underwood pushing things, sometimes it can be tricky to get things in the House and the Senate.
And that's a great point, Nathan, because it's one of the reasons why we wanted to do this briefing and to introduce everyone to our groups, so that you can use any one of us as a resource as you start to look at the bill. It is a technical bill. There are differences between the House and the Senate, and we want folks, since it's definitely not being driven by one party or the other, we want folks to be able to come and ask questions of us about specific provisions, so that your bosses can be informed when they make decisions on the floor. So we're running out of time. We should wrap it up here. I don't know if anybody had any other points they really were burning to make.
And we'll be around afterwards.
Yeah. Okay. And please come and get everyone's card, and please feel free to reach out to all of our panelists. Thanks, guys, for doing this. Okay.
Thank you. Enjoy the library. You can read some books, I guess.